There are many different types of contracts in the legal system. An express contract is a legal agreement in which the terms are transparent and known to all parties involved. An implied contract is a contract that is implied or inferred by the parties' conduct. For example, at a restaurant, it is implied that after eating dinner, the customer will pay the bill. Most contracts are under seal, a formal, written contract that is signed, witnessed, and marked with a seal. A simple contract is a contract that is not under seal. That is, it may be verbal, written, or implied. In an offer and acceptance, the party who initiates or makes the offer is known as the offeror. The party to whom the offer is made is known as the offeree. In a valid contract, there must be a serious intent on the part of the offerer. The offer must also contain definite terms or details. Some terms are clearly defined while others are implied. When a company or business encourages the purchase of a product or service through advertising, this is an invitation. A contract occurs when the product or service has actually been purchased. Part of an offer includes communicating the proposed contract to the offeree. Common methods include communication in person, by mail, courier, fax, and email. Communication is not successful unless it is received by the offeree. An offer can be terminated or cancelled for various reasons. A lapse occurs when an offer is not accepted within a period of time and the offer ends. An offer may also be revoked or cancelled by the offerer before it can be accepted. Similarly, the offeree has a responsibility to clearly communicate its acceptance of the proposed agreement. Offers may be accepted using the same methods of communication, for example, mail or courier. An acceptance must occur before a specified time limit or the offer expires. The offeree may decide to make a counteroffer, which is a new offer or amendment to the original offer. Any counteroffer ends the original offer. After an offer is accepted, something of value must be exchanged between the parties who are involved in the contract. The actual value or amount exchanged between the two parties does not matter to the courts. A contract can appear to clearly favor one side over the other. A court simply wants to see that there is some degree of exchange or consideration involved in the contract. A contract will only be considered valid in court if the offerer and offeree has the capacity to understand what they are agreeing to. Anyone with a developmental disability, impaired judgment, or who is under the age of majority in Canada does not have the capacity to enter into a valid contract. A minor may enter into a valid contract if it is considered necessary to ensure his or her health and welfare, for example, an employment contract. If a contract is not considered to be in the minor's best interest, it is declared void. In general, each party in a contract must freely agree or consent to the contract. An offeree must completely understand the terms of the contract. There are some situations that may prevent consent from occurring: misrepresentation, mistake, undue influence, or duress. Misrepresentation is a false statement about a material fact that is so important that it causes the other person to enter a contract. This makes genuine consent impossible. Innocent misrepresentation occurs when a person incorrectly believes something to be true. For example, a sales clerk repeats a manufacturer's false claim about a product. Fraudulent misrepresentation occurs when one party tries to deceive the other on purpose. For example, a person intentionally lies about his or her car in an effort to sell it. Both types of misrepresentation allow a buyer or offeree to back out of the contract. Certain kinds of mistakes can make a contract unenforceable by law. A common mistake occurs when an error is made by both parties in the contract. For example, an agreement is made to purchase a product that is out of stock indefinitely. A unilateral mistake is when one party to the contract makes a mistake and the other party knew of it but did not try to correct it. For example, buying a product to use for a purpose it was not intended for. The clerk is aware that the product will not work for that purpose but does not say anything. A clerical mistake is an error caused by a clerk or store employee. Clerical mistakes often involve numbers, such as incorrect prices. When one party applies pressure on the other, for example, an aggressive salesperson, to form a contract, this is undue influence. Any contract that is formed with undue influence lacks proper consent and will be declared void. Duress is similar to undue influence. When one party uses threats such as blackmail or violence to intimidate the other party into forming a contract, that agreement will also be cancelled. No contract can violate any provision of the Criminal Code in Canada, as well as any provincial law or municipal bylaw. Any contract that is found to break the law will be declared void immediately. Each contract must have a lawful objective or purpose. Certain contracts require special rules or regulations, as well as government intervention. For example, betting, gaming, and gambling.